Welcome to this deep dive into EU competition policy. We've designed this specifically to help you understand and, importantly, study this crucial area for your exams.
That's right.
And just to be clear, this material is provided by the University of London and made available to students. So this discussion is purely for educational purposes, really aiming to help you get a solid grasp of the key concepts you'll need.
Absolutely.
This deep dive is brought to you by Sinorbit Academy, Sri Lanka. And from both of us, good luck to all of you with your exams.
Yes, best of luck.
Okay, so today we're tackling the core principles of EU competition policy. We'll be focusing mainly on Articles 101 and 102 of the Treaty on the Functioning of the European Union, the TFEU.
Yeah, those are the big ones.
And also the vital framework set out in Regulation 12,003. Our mission here is really to pull out the most important bits, the key nuggets, to give you that solid understanding.
It's not just a summary, is it? It's about digging in.
Exactly. It's a focused exploration. We want you to feel confident and well prepared. Okay, let's unpack this. How does the EU actually ensure, a level playing field for businesses? What are the main tools it uses?
Well, that's a great starting point. You have to remember, EU competition policy isn't new. It goes way back to the 1957 EC Treaty.
Right.
And its core objectives, they're really about building and maintaining a healthy single market.
Right.
So that means promoting economic efficiency, ensuring resources are allocated effectively, and crucially, fostering innovation.
Okay.
And something that's really central is the emphasis on consumer welfare. The whole point, really, is to stop things like excessive prices or poor quality goods or consumers having very limited choices.
So consumers are key.
Absolutely.
Yeah.
And there's also a definite focus on protecting smaller players, the SMEs, small, medium-sized enterprises, making sure they don't get squeezed out by the big guys.
Okay. Protecting consumers and smaller businesses, that really clarifies the goal. Now, the primary law, as you said, is in Articles 101 to 109 TFEU. But today, we're zoning in on 101 and 102.
The workhorses of competition law.
Exactly. You could think of Article 101 as the rule book for playing fair with competitors, while Article 102 deals with the special responsibilities that come with being a dominant player.
That's a good way to put it.
So 101 covers agreements, concerted practices, and decisions by associations, and 102 tackles the abuse of dominance.
Correct.
And it applies really broadly, doesn't it? I mean, even something like organizing football competitions and selling the media rights that's seen as an economic activity subject to these rules. We saw that in the recent Super League case, C33321.
Yeah, sport is definitely business in the eyes of competition law.
So where should we dive in first? Article 101.
Let's start there. Article 101 TFEU really lays the groundwork. Now, for your exams, remember this. There are three key requirements to show a violation. Three things.
Okay, three things. Got it.
First, there has to be an agreement or some kind of collusion or maybe a decision by an association of undertakings.
Right.
Second, this agreement or practice, it must have an effect on trade between member states. That's the cross-border element.
Okay, affects trade between states.
And third, its object, its purpose or its effect must be to prevent, restrict, or distort competition within the internal market.
Object or effect. Okay, so the first hurdle then is defining these terms. Let's start with undertaking. That sounds quite formal. Is it just big companies?
No, not at all. The definition of undertaking is actually very broad. You need to remember the case C4190 Huffner and Elster.
Hofner and Elster. Okay.
That case established that an undertaking is basically any entity engaged in an economic activity. It doesn't matter what its legal status is or how it's financed.
Any entity. So partnerships, sole traders.
Yep. Companies, partnerships, sole traders, cooperatives, even some nonprofits if they're involved in economic activity. It's about the activity, not the legal form.
That is broad. Are there exceptions?
There are. For instance, C20503P-MENN. In that case, the court said state bodies buying goods with public money for public health use, specifically not for resale, generally aren't acting as undertakings because they aren't offering goods or services on a market.
Ah, okay. So if they're acting purely as a public authority.
Exactly. But if that same body started, say, selling those goods or offering a service on the market, even subsidized, it could potentially become an undertaking for that activity.
Makes sense. And what about parent companies and their subsidiaries? Are they always separate undertakings?
Usually not, no. They're often treated as a single undertaking.
Yep.
The key case here is case of 1574 Centrifarm v. Sterling Drug.
Centrifarm. Got it.
If the subsidiary doesn't really have freedom to decide its own market actions, if it basically forms one economic unit with the parent, then agreements just between them about internal stuff like allocating tasks don't fall under Article 101. And the Alliance 1 international cases, C62810P and C4211P, confirm this. If the parent exercises decisive influence over the subsidiary's commercial policy, they're likely a single undertaking. So, Central Farm and Alliance 1 are important for that single economic unit idea. Remember those for the exam.
Single economic unit. Okay. So moving to agreement, that sounds like it's interpreted widely too.
Very widely. Case C56 and 58864, Constant and Grundig, that's a landmark case. It made clear agreement isn't just horizontal ones between competitors.
Right.
It also covers vertical agreements, like between a manufacturer and a distributor.
Okay, up and down the chain.
Exactly. And crucially, it doesn't have to be a formal written contract. Cases like 41, 44, and 4569 ACF Chemi Pharma show that even informal gentlemen's agreements are caught.
Wow, so even a nod and a wink could be trouble.
Potentially, yes. It's about the meeting of minds, the consensus. And these agreements can be long-lasting, as the polypropylene case showed. A company could be part of a cartel even if they missed a few meetings,
Right.
Proving it usually falls on the authority alleging infringement. That's Commission v. Anec Partecipazioni, C4992. But sometimes, even unilateral action can lead to an agreement.
How does that work?
Well, think about the Volkswagen decision. If a manufacturer imposes restrictive terms on its dealers, and the dealers basically go along with it, that acquiescence can form a tacit agreement.
Ah, okay.
But, and this is important, there needs to be a common interest or concurrence of wills. The Bear-Adelot case showed that just continuing to do business isn't enough if the distributor doesn't actually agree with the manufacturer's restrictive policy. Unilateral behavior itself isn't enough without that meeting of minds. Definitely remember Bear-Adelot for that point.
Okay, tacit agreement requires that concurrence of wills, and then there are decisions by associations of undertakings. What's covered there?
This is also quite broad. Case 9682 IAZ International showed it includes things like recommendations or codes of practice, even if they aren't strictly binding, if members tend to follow them.
So industry guidelines.
Potentially, yes. And rules set by professional bodies, too. In C30999 Waters, the Dutch Bar Association was considered an association of undertakings, and its rules were scrutinized under Article 101. Same for professional accounting bodies' training rules in Case 112, Orden dos Técnicos Oficiais de Contas.
Right, so groups regulating professions aren't exempt. Now, concerted practice, that sounds a bit more, well, subtle than an agreement.
It is. It's about coordination that falls short of a formal agreement.
Yeah.
Case 4869 ICIV Commission, the dyestuffs case, is the absolute classic here. You need to know dyestuffs.
Okay, dyestuffs.
A concerted practice is basically coordination where companies knowingly swap the risks of competition for practical cooperation. They align their behavior without necessarily having a signed deal.
Like those bakers you mentioned, subtly signaling price rises.
Exactly that kind of thing.
Yeah.
The court in dyestuffs rejected the idea that simply acting similarly in an oligopoly-conscious parallelism was automatically okay. There needed to be some contact or coordination. And Sucre-Uni, case 4073, clarified it further. Any contact, direct or indirect, that aims to influence a competitor's behavior or reveals your own intentions can be enough. No need for a full-blown plan.
So just sharing future price intentions could be risky.
Highly risky.
Yeah.
And it doesn't matter if the competitor you're agreeing to exclude is acting unlawfully, like in case C681 Slovenska Sporitelna. Colluding to exclude them is still a breach.
Right.
However, the conscious parallelism argument isn't dead.
Yeah.
The Re-Woodpulp case, C89, etc. 85, showed that if there's a plausible alternative explanation for parallel behavior, it might not be a concerted practice. But just saying we all did the same thing isn't usually enough.
You need a good reason other than collusion.
Precisely. And exchanging sensitive information, that itself can be a concerted practice. The authorities often use a joint classification approach. Now, they don't always have to rigidly label it an agreement or a concerted practice.
No.
And importantly, you don't need to prove actual market effects for a concerted practice. That was confirmed in Hull's AGV Commission, C19992. The potential effect is enough.
Right. And you mentioned the leniency notice.
Yes, that's a key enforcement tool. It encourages companies involved in cartels to blow the whistle in exchange for immunity or reduced fines. It's vital for uncovering secret collusion.
Makes sense. Now, we mentioned horizontal and vertical agreements earlier. Just quickly again, the difference.
Sure. Horizontal, between competitors, same level. Think manufacturer A and manufacturer B, vertical,
Yep.
different levels. Manufacturer and distributor, or distributor and retailer.
Got it. And Constant and Grundig confirmed vertical ones are caught by 101.
Absolutely. Even though sometimes vertical agreements can actually help competition between brands, for example, by helping a new product get established in a market.
Interesting. Okay, so we've got the agreement decision practice part. Now, the object or effect of restricting competition, that or is really important, you said.
Crucial. Again, Constant and Grundig is key. The court said object and effect are alternatives. If an agreement has an anti-competitive object, meaning its very purpose is to restrict competition, like price fixing or market sharing, it's illegal per se.
Per se illegal, meaning...
Meaning you don't need to prove it actually harmed the market. The intention, the object, is enough. The T-Mobile Netherlands case, C808, confirmed that even the potential to restrict competition is enough for an anti-competitive object.
Okay.
If, however, the agreement doesn't have an anti-competitive object, then you need to look at its actual or potential effects on the market.
And how do you assess the effect?
You look at the context. Case 5665, STM v. Machine and Bell Ulm mentioned factors like the nature of the products, the market position of the companies involved, how easy it is for other competitors to enter the market, that sort of thing.
Right.
And remember the cross-border element. Even if all the companies are in one country, if their deal makes it harder for firms from other member states to compete there, it likely affects trade between member states. That was the point in Simon-Thanelaran v. Commission, case 872.
So intention or potential harm is enough for object, otherwise you look at actual market effects.
Got it.
And the de minimis rule, where does that fit? Is it an excuse?
Sort of, but not exactly an excuse. It's not actually written into Article 101. It came from case law, starting with case 569 Volk. It basically says that if an agreement's effect on competition and trade is genuinely negligible, perhaps because the companies involved are very small, then Article 101 might not apply.
Okay, negligible effect.
The Commission has a Notice on Agreements of Minor Importance. The 2014 one is current, which sets out market share thresholds below which agreements are generally considered de minimis. But, and this is but it doesn't apply if the agreement contains hardcore restrictions.
Like price fixing.
Exactly. Price fixing, market sharing, limiting output, those kinds of serious restrictions. If your agreement has those, the de minimis rule won't save you, no matter how small you are.
Right. No de minimis for hardcore restrictions. Now, you mentioned the EU has this two-step process. 101 prohibits, then 101.3 potentially exempts. How is that different from the U.S. rule of reason?
That's a really important distinction, especially for comparative law questions. The U.S. often uses a rule of reason, where they weigh the pro and anti-competitive effects up front to decide if there's an infringement at all.
Okay.
The EU system, confirmed in cases like Metropole Television, M6V Commission, T11299, is different. If an agreement falls under 101, either by object or effect, it is prohibited. Then you look separately to see if it qualifies for an exemption under 101.3. The balancing act happens mainly at the 101.3 stage.
So, guilty until proven exempt, in a way.
You could simplify it like that, yes.
Right.
If you meet the 101.1 criteria, the agreement is automatically void under 101.2, unless you can satisfy all the conditions in 101.3. Remember that two-step structure for your exams.
Okay, let's look at those conditions in 101.3. What does an agreement need to show to get that exemption?
There are 4 cumulative conditions, meaning you have to meet all 4. 2 are positive requirements, 2 are negative.
Okay.
Positive 1. The agreement must contribute to improving the production or distribution of goods or promote technical or economic progress.
Right, efficiency gains.
Positive 2. Consumers must receive a fair share of the resulting benefit. It can't just benefit the companies.
Fair share for consumers. Got it.
Negative 1. The restrictions in the agreement must be indispensable to achieving those benefits. You couldn't achieve the good stuff without the restriction.
Indispensable.
And negative 2. The agreement must not give the companies the possibility of eliminating competition for a substantial part of the products in question.
Can't eliminate competition. Okay, those 4 seem clear. And how do companies get this exemption now? Is it automatic?
It is now, yes, in the sense that it's directly effective. Before 2004, under Regulation 1762, companies had to notify the Commission and get individual approval. That system is gone.
Oh, okay.
Regulation 12,003 made Article 101.3 directly effective. This means companies self-assess if they meet the criteria. National competition authorities and national courts can also apply 101.3 directly now.
So the onus is on the company to be compliant.
Exactly. And to help with that self-assessment, especially for common types of agreements, the Commission issues block exemptions.
Ah, yes, block exemptions. What are they?
They are regulations that basically say, if your agreement fits into this category and meets these specific conditions, it's automatically presumed to satisfy Article 101.3. a big one covers vertical agreements. Regulation 330210 is the current main one.
Okay.
There are also block exemptions for things like technology transfer agreements, R&D agreements, specialization agreements. They provide legal certainty for businesses engaging in those types of potentially beneficial cooperation.
Very helpful. Okay, that covers Article 101 pretty thoroughly. Now, Regulation 12,003, you said it brought a big change in enforcement. Let's talk about how these rules are actually put into practice. What did Regulation 12,003 really do?
It was a fundamental shift, often called the modernization of EU competition enforcement. The single biggest change was decentralization.
Decentralization, away from just the Commission in Brussels.
Precisely. Before 2004, the Commission had a near monopoly on applying Article 1013 and enforcing the rules effectively. Regulation 12,003 created a system of parallel competences,
Meaning
both the European Commission and the national competition authorities. The NCAs in each member state now have the power to fully apply Articles 101 and 102.
Okay, so multiple enforcers.
Yes, and they work together within the European Competition Network, the ECN, to coordinate efforts and ensure consistency. The idea was to spread the workload, let NCAs handle cases with more local impact, and allow the Commission to focus on the biggest, most complex or cross-border cases.
And it put more responsibility on companies, too.
Absolutely. With the end of the notification system for 101 and 3, companies now have to self-assess whether their agreements are compliant.
Okay. Can you highlight some key articles in Regulation 12,003 we should know?
Sure. Article 1 confirms the direct effect of 101, especially 101. Article 3 is crucial. It obliges NCAs and national courts to apply EU competition law, Articles 101 and 102, whenever an agreement or practice might affect trade between member states. It also confirms the supremacy of EU law over conflicting national law.
Right, EU law first.
Article 5 lists the powers of NCAs. They can demand information, conduct inspections, order infringements to stop, accept commitments, impose fines, basically enforce the rules fully. Article 6 confirms that national courts also have jurisdiction to apply 101 and 102 directly in private disputes.
So individuals can sue in their national courts, too.
Yes. The Commission retains significant powers too, of course. Article 7 covers finding infringements and imposing remedies. Article 8 allows for interim measures in urgent cases. Article 9 lets the Commission accept binding commitments from companies to address competition concerns. And Article 10 allows the Commission to issue decisions finding no breach.
Okay. In this ECN network, how does the cooperation actually work?
Chapter 4 of the regulation sets that out. Article 11 requires NCAs and the Commission to inform each other about new cases and intended decisions. There's a system for allocating cases, often based on the best-placed authority principle, usually the one where the effects are strongest, or the Commission if it affects more than 3 member states.
Right.
Articles 12 and 13 deal with exchanging information and preventing parallel proceedings. Article 15 is interesting for national courts. They can ask the Commission for information or an opinion on applying the rules, and they have to send copies of their judgments applying 102 to the Commission.
To keep track of how it's being applied nationally.
Exactly. And Article 16 ensures coherence by stating that national courts and NCAs cannot take decisions that would conflict with a decision already adopted by the Commission.
A very integrated system. What about investigation powers, searches?
Chapter 5 gives the Commission strong powers. They can conduct inspections, dawn raids at company premises. Article 25 requires NCAs to assist the Commission. Article 21 even allows searches of private homes of directors or staff if there's reasonable suspicion. Relevant documents are kept there, though that needs judicial authorization.
Wow, searching homes, that's serious.
It is. And the penalties in Chapter 6 are serious too. Article 23 allows fines up to 10% of a company's global turnover for the preceding year for infringing Articles 101 or 102. There are also fines for supplying incorrect information or obstructing inspections. Article 24 allows for periodic penalty payments to force compliance.
10% of global turnover, that's a massive deterrent. And those guidance notices from 2004.
They're really important for understanding how the Commission and NCAs interpret and apply the rules in practice. They cover cooperation within the ECN, cooperation with courts, how the Commission handles complaints, guidance on interpreting effect on trade, and crucially, detailed guidance on applying the Article 101(3) criteria. There's also a procedural regulation, 7732-204, that sets out the nuts and bolts of Commission proceedings.
Okay, essential reading for understanding the practical side. Right. Let's switch gears to Article 102, TFEU, abuse of dominance. This is about the big fish, right?
Exactly. We've covered agreements under 101. Article 102 deals with unilateral conduct by companies that hold a dominant position in a market. It's crucial to remember, Article 102 doesn't prohibit being dominant. Having a large market share isn't illegal in itself.
Right. It's the abuse that's prohibited.
Precisely. And what constitutes abuse for a dominant company might be perfectly legal, competitive behavior for a smaller firm. Because of this, applying Article 102 requires quite a detailed economic analysis.
Okay, what's the first step in that analysis?
Defining the relevant market. You can't know if a company is dominant unless you know the market it's operating in. This involves defining both the relevant product market and the relevant geographic market.
Right. How do you define the product market? You mentioned interchangeability earlier.
Yes, that's key. From the consumer's perspective, what products are reasonably interchangeable or substitutable because of their characteristics, price, and intended use? That's the core question from Case 2776, United Brands.
United Brands. Bananas, wasn't it?
That's the one. The court asked if other fruits were really substitutes for bananas for most consumers. You also look at cross-elasticity of demand. If the price of product A goes up, do customers switch to product B?
Like coffee and tea.
Potentially, yes. You also consider supply-side substitutability. Can producers of other goods easily switch to making the product in question? Case 32281 Michelin showed that tires for cars and tires for trucks were different product markets. The Commission uses the SSNIP test, small but significant non-transitory increase in price, outlined in its market definition notice to help define markets systematically.
Okay, SSNIP test. And the geographic market.
That's the area where the conditions of competition are sufficiently homogeneous, where sellers compete and buyers buy under broadly similar conditions. Again, United Brands is relevant. It could be local, national, EU-wide, or even global, depending on the product and how it's traded.
So market definition is step one. Step two must be assessing dominance within that market.
Correct. Once you've defined the market, you ask, is the company dominant? The classic definition, again from United Brands, is a position of economic strength that allows a company to behave to an appreciable extent independently of its competitors, customers, and ultimately consumers.
Acting independently. How do you measure that market share?
Market share is usually the starting point and a very important indicator. Case 6286 AKZO Chemi suggested that a market share consistently above 50% is a strong presumption of dominance.
Above 50%.
But it's not automatic. Below 50%, dominance is still possible, though less likely. Above 50%, it's presumed, but can be rebutted. You also look at how stable the market share is over time. Hoffman-LaRoche, Case 8576. And the gap between the company's share and its nearest competitors. British Airways, KC 9504. Remember AKZO, Hoffman-LaRoche, British Airways for assessing dominance?
So high market share is a big flag, but you look at other factors too.
Absolutely. Barriers to entry are crucial. If it's really hard for new companies to enter the market and challenge the incumbent, that strengthens the finding of dominance.
What kind of barriers?
Things like legal monopolies or regulations,
Yeah.
Tetra Pak, Case 33394P, superior technology or IP rights, United Brands, Michelin, Hoffman-LaRoche, having huge financial resources, deep pockets, United Brand, Continental Can, economies of scale, controlling distribution channels, United Brands, Hoffman-LaRoche, or even just a very strong brand image, United Brands.
Lots of potential barriers. And dominance needs to be a substantial part of the internal market.
Yes, there's a geographic element, but substantial part doesn't mean huge. Even a region within a member state like Southern Germany and Sukayuni can qualify. It's more about economic significance.
Yeah.
And importantly, dominance can also be collective.
Collective dominance, multiple companies.
Yes, where two or more legally independent companies are linked in such a way, perhaps through structural links or economic factors in an oligopoly, that they jointly hold a dominant position and act together like a single entity. Company Maritime Belge is a key case. It can even apply vertically, as in Irish Sugar.
Okay, so you can have joint dominance too. Now, the crucial part, the abuse. What actually counts as abuse by a dominant company?
The definition from Hoffman-LaRoche is central. Abuse is conduct which, through recourse to methods different from those governing normal competition, has the effect of hindering the maintenance or growth of the competition that still exists.
So competing unfairly, basically.
Yes, not competing on the merits, like by having better products or being more efficient. It's using your market power to harm competition or exploit consumers. Article 102 gives examples like unfair prices or trading conditions, limiting production, discrimination, tying. But the list isn't exhaustive, as Michelin confirmed.
Right.
Abuses are often categorized as exploitative, harming customers directly, like excessive prices, or anti-competitive, exclusionary, harming competitors, and thus indirectly harming consumers through reduced choice or innovation. Remember, a dominant company has a special responsibility, Michelin, not to impair genuine competition.
Unlike Article 101, there's no 101 style exemption for abuse.
Correct. There's no exemption mechanism.
Mm.
However, conduct that looks abusive might sometimes be objectively justified, for example, if it's necessary for technical or safety reasons, or based on legitimate efficiency gains that ultimately benefit consumers. But the bar for objective justification is high.
Okay. What are some common types of abuse we should know for exams?
Well, excessive pricing is one, though notoriously hard to prove, AKA C1, C7, and 16. More commonly litigated are exclusionary abuses. Predatory pricing below cost to drive out rivals is a classic example. See AKZO-AMI.
Pricing below cost. Okay.
Discriminatory or selective pricing, charging different prices to similar customers without justification, can be abusive. Irish Sugar. Loyalty-inducing rebates or fidelity discounts, where you get discounts for buying exclusively or almost exclusively from the dominant firm, are often problematic. See Hoffman-La Roche, Michelin, British Airways. The post-Danmark case, see 2010, added nuance, requiring analysis of the likely foreclosure effects and potential justifications.
So discounts can be abusive.
If they have the effect of tying customers and foreclosing competitors, yes. Tying is another abuse, making the purchase of one product conditional on buying other unrelated product. Tetra Pak is a key case. This can leverage dominance from one market into another.
Right. What about refusing to deal with someone?
Refusal to supply can be an abuse, especially cutting off supplies to an existing customer without objective justification. Commercial solvents, United Brands. It's particularly scrutinized if the product is an essential input for the customer's business.
Essential input.
And that leads to the essential facilities doctrine. This is where a dominant firm controls an infrastructure or asset like a port, a network, maybe even IP, that competitors absolutely need access to in order to compete in a related market. Refusing access can be an abuse.
Like the bridge example, what are the key cases?
Bronner v. Mediaprint set a very high threshold. The facility must be indispensable, no viable alternatives. Refusal must be likely to eliminate competition, and it must be unjustified. IMS Health added further cumulative conditions related to preventing new products and consumer demand. Refusing to license intellectual property is generally allowed, but can be abusive in exceptional circumstances. Microsoft, IMS Health.
Exceptional circumstances.
And the recent Google Android case, T60418, is massive. It confirmed abuse through tying Google Search and Chrome apps to the Play Store license, preventing phone makers using alternative Android versions, and paying manufacturers for exclusivity. It showed how these principles apply in the digital age and confirmed huge fines are possible.
Google Android, a key modern example then. Now, if a company does break these rules, can victims claim damages?
Yes, absolutely. Victims of antitrust infringements, whether under Article 101 or 102, have a right under EU law to claim compensation for the harm suffered. However, the actual process for claiming damages is mostly governed by the national laws of the member states.
Okay.
Directive 2014-104 was introduced to make it easier for victims to bring these damages actions across the EU, harmonizing certain procedural rules. The Otis case, C43588, relates to the application of this directive.
Makes sense. And finally, mergers. How do 101 and 102 interact with company takeovers?
Initially, before specific merger control existed, Articles 101 and 102 were sometimes used. Continental Can showed acquiring a competitor could be an abuse of dominance under 102, but only if the acquirer was already dominant.
Right.
Article 101 was trickier. Could acquiring shares in a competitor be an anti-competitive agreement? The BD cases explored this, but it led to uncertainty. This ultimately highlighted the need for a dedicated system.
Which led to the merger regulation.
Exactly. First Regulation 406489, now replaced by Regulation 139-2004. This provides a specific framework for reviewing concentrations, mergers, acquisitions, certain joint ventures above certain turnover thresholds before they happen. It's a distinct area of competition law, really beyond our scope today, but it grew out of the limitations of applying 101 and 102 to mergers.
Okay, that puts it in context. This has been incredibly helpful, a really thorough run-through. Before we finish, any final killer study tips for our listeners focusing on EU competition law exams?
Absolutely. Okay, for Article 101, really nail down those three core requirements: agreement, practice, decision, effect on trade, object, or effect restricting competition. Know the key cases that define those elements, especially undertaking, Huffner, agreement, Constant and Grundig, concerted practice, die steps. Understand the object effect distinction, that's crucial, and memorize those four conditions for exemption under 101.3. Know them cold.
Four conditions, got it.
For Regulation 12,003, understand the shift to decentralization, the ECN, and the basic powers of the Commission and NCAs. Self-assessment is key now.
Right. Yeah.
For Article 102, focus on the two-stage analysis. First, market definition product, United Brands, Michelin, and geographic. Use SSNIP. Second, assessing dominance market shares, AKZO, barriers to entry, other factors, Hoffman-La Roche, British Airways.
Market definition, then dominance.
Then, learn the main types of abuse and link them to key cases. Predatory pricing, AKZO. Rebates, Hoffman-La Roche, post-Denmark. Refusal to supply commercial solvents, United Brands. Tying Tetra Pak. Essential facilities, Bronner, IMS Health, Microsoft, and the big recent one, Google Android.
Link abuse types to cases. Excellent tip.
Yes. Understand the special responsibility of dominant firms. And remember the difference between the EU's 101 approach and the U.S. rule of reason. When you study cases, don't just learn the name. Focus on the key facts, the legal question, and the court's core reasoning. That helps you apply the principles.
Fantastic advice. We really hope this focused exploration has given you a much clearer understanding of EU competition policy and, crucially, some effective ways to study it.
Remember to go back to the core texts, the essential readings, and explore that case law.
Yes, definitely. And check the Am I Ready to Move On? Questions in your materials. They're great for self-testing. From both of us, we wish you the very, very best in your preparation and your exams. Remember to apply these concepts and cases in your answers.
Good luck.
And on that note, that's all for this deep dive. Until next time.